My first one is, can dependency rightfully take jurisdiction without a fitness hearing or proving a parent unfit?
Yes.
Okay. Even if it's against, I thought it was against constitutional rights.
Well, the answer is okay, we're back. I'm attorney Vincent Davis. I'm here with my co-hosts, Ms. Erin Carranza and Mr. Brian Hamilton. Before we take the next call, Brian, briefly tell people what you do and how they can get in touch with you. Can't hear you, Brian. Okay. We'll try one more time. Erin.
There we go. Okay, sorry. Yeah.
Okay. So how can people get in touch with you, Brian? You're a therapist that works with people involved in CPS cases.
Yeah, I'm a therapist at a Life Source Affordable Counseling. They can contact me at my cell phone number, 951-289-0478. You can also look me up on Psychology Today, or you can also go to the Life Source Affordable Counseling website and see my profile there. So.
Okay, perfect. Let's take another call right now from up north in California. Fargo. Fargo, did you have a story to tell or a question to ask?
I have a couple questions to ask if possible, or three if we have time. My first one is, can dependency rightfully take jurisdiction without a fitness hearing or proving a parent unfit?
Yes.
Okay. Even if it's against, I thought it was against constitutional rights.
Well, the answer is no. Your thought would be not correct.
Okay.
Anytime a child is believed to be at risk of harm, either physically or emotionally, the social worker can file a case. And once they file the case, the judge has jurisdiction, so to speak. The judge has to make some findings at a jurisdictional and dispositional hearing, but the judge has temporary jurisdiction until he or she determines that they have a full jurisdiction over the child. Okay.
How do they figure out if they have a full jurisdiction?
I'm sorry?
And they would find out they have a full jurisdiction by what, the case report?
Yeah, no, by having a trial or a hearing called the jurisdictional hearing. At the jurisdictional hearing in California, and yes, you're in Northern California, the social workers have to prove by a preponderance of evidence that the child falls under Welfare and Institutions Code Section 300. And there's different subsections to 300, okay, that may or may not apply. And then after that, the court has to do what's called a dispositional hearing, and the social worker, if the social worker is trying to keep the child away from you, the social worker has to prove by clear and convincing evidence that that you're a substantial danger to a child, and by clear and convincing evidence that there are no less restrictive alternatives other than placing the child outside of your care. By the way, that last one is it's hard to do. Sometimes I see it easily applied, and I disagree with how it's applied a lot of times. But that second one's really hard to do, in my opinion.
Well, I had a dispositional hearing, and they didn't have any clear and convincing evidence against me that I'm unfit, and they still changed the orders and took away my son. And, well, I have visitation with him every other weekend, but they gave him to his father, and he's always in with his dad. So my other question is,
wait a minute. There's a little change in that. If the child is not placed in foster care but is already placed with the other parent, the test is different. The test is preponderance of evidence. They have to prove that you're a substantial risk. And
they did.
Go ahead.
But they didn't.
I can assure you.
He's at risk being there. I contested the choice and everything, and we had a hearing again and there was no preponderance of evidence. There's no evidence showing that I was either at risk with me or in danger with me.
Well, if that is your belief, what you and your attorney should do is file a notice of appeal and take it to the
Yeah.
take it to the court.
Sorry, that leads me to my next question.
Okay, go ahead.
So my next question was, how do you get, if you miss the year mark by like a week to appeal, then how can I file for a motion to dismiss or void?
You can't.
There's no other way to get to appeal.
I didn't understand quite what you were saying.
So I want to appeal the original judgment order, and it's been like a week past the date they were filed.
Okay, so you have to file.
Like a week past the year mark.
Okay, so what you must do within 60 days of the dispositional order, Fargo, you must file what's called a notice of appeal. And it's a 1 to 2 page form that you just fill out and file with the clerk of the court. If you file it past the 60 days, you may be out of luck absent a certain type of special motion to the court to allow you to file a late notice of appeal. There are rare occasions where that might be accepted, but most times if you've missed that date, you're going to have to wait till your 6-month hearing.
Yeah, no, I'm already in family court now. I've been dismissed out of dependency, but I missed the appeal date. Like, you have a year to appeal after the final judgment order, and I missed the year date by like a week. And so I was trying to get 2 appeals based on some grounds where I feel like the judgment orders should have been void because they took custody. The reason they took custody was untrue and false, stated by the caseworker. And I have proof of, the social worker supervisor telling me, well, we took custody because you violated the safety plan. But then I have a copy of the safety plan that says nowhere in it anything she's talking about in email. She says I shouldn't have taken my son into custody according to the safety plan, which is why I violated it and which is why they took custody. But in the safety plan, it doesn't say that anywhere.
Okay, Fargo.
Because, as needed.
Fargo, here's the problem. You have a problem that I don't even think you may realize. The time to an appeal a judgment of a court or an order of a court, if it's appealable at all, is 60 days in California. I'm not sure where you're getting this 1-year date. So,
if there was a mistake made in the course of the hearing, it said according to the rules of law in California on the website that I saw, it says that you have up to a year to appeal an order.
No. So I don't know if they were talking about California law, but I can tell you, having been an attorney almost 35 years, you only have 60 days. Now, if your juvenile dependency case is closed, and you're in California, what you have to do is, and you haven't appealed, what you have to do is go to the family law court and file file a request for order to change the custody and visitation. And
modification. I've done that already once. I do my second one on Tuesday.
Okay. Are you doing that with a family law attorney?
I tried to do the first modification with the family law attorney, and I ended up losing $10,000, and he asked one question during the hearing. So I've been in touch with a constitutional scholar and, done a lot of research myself. And I'm self-representing because I can't afford anymore.
Okay, so I just want to tell you this, and I don't know who you've been talking to. They may be great, truly constitutional scholars, but I'm involved in a case right now, and my client found some quote-unquote constitutional scholars and had me talk to them about the case. And I spoke to them, and I was polite and courteous, but afterwards, I had determined that they weren't really constitutional scholars. They weren't even lawyers. So be careful when somebody starts talking to you about constitutional claims. Constitutional claims are real. They can help you in most cases. Okay?
Yeah, that's what I was trying to do. What I'm trying to do, I'm in modification, and your liberty is your children. And if the Bill of Rights says that we have a right to, life, liberty, and pursuit of happiness or not, and that we can, deprivation of that is, that's constitutional right. That depriving my child when I'm not unfit for me, and, when my child's under duress and under emotional stress and
2 minutes.
And cries every time he's with me every other weekend, then that's, I don't know how to get these orders thrown out that are totally false, made by a completely corrupt and alleged, allegations against this judge. for being corrupt and doing multiple things wrong out of it was misconduct. And still, she's on the bench, dependency, and she filed these orders, and there's lies all through them. And I tried to get the transcripts to prove it, and the person's telling me I can't get the transcripts because I have to file a motion to get approval because they're confidential. But I was the one in the hearing speaking, and telling I can't get them.
Okay.
It's just family law is so ass
Fargo,
backwards as far as protecting the parents and the children.
Fargo, let me ask you this question. Are the constitutional scholars that you were referring to, are they lawyers?
No, but they state that. Most anybody who isn't a lawyer states, I'm not a lawyer, this is not legal advice.
Okay. So if you're trying to get the transcripts from the court, from the juvenile court case, you can only do that by following something called Welfare and Institutions Code section, I think it's 827 here in California. You can't just go and ask and claim a constitutional right. Okay.
No, it has nothing to do. The constitutional rights have nothing to do with me trying to get the transcripts.
Oh, okay.
That was separate.
All right. So
no, I was told by the person who transcribed the reports of the hearing. That, first she told me it was $500 basically per page, per 100 words or something, and then after that she said, "Oh, I'm mistaken. You have to, go to the court and petition or request to get these orders first."
Yeah, that is true in California.
And it's my case.
Fargo, if you're trying to get transcripts from a juvenile dependency case in California, there is a process you have to file and you have to follow. And the judge, get this, the judge in the juvenile dependency court case has to allow it. Hey, Fargo, we got to take our next break. I want to thank you for calling and thank you for listening. Call us back in about 3 or 4 weeks and give us an update. This is The Secret, How to Fight Child Protective Services and Win. We'll be right back after these messages.